Yeah. I'm going to focus principally on the First Amendment. There's not much I can say about the Constitution.
Right. Oh, they embrace it. Also,
good afternoon, ladies and gentlemen. It's 12:03, which is the new 12 in Missoula. Started just a little late so we could get everyone set up. Thank you for joining us this afternoon. My name is John Ing, and I have the privilege of serving as the mayor of the city of Missoula and the privilege of introducing our topic and our panel today. The topic is By the People, a discussion about corporate influence on our democracy. You know, some of the folks in this room, as I look around, are old enough to have been kicking around Missoula when K. Ross Toole told the story of Montana in a crowded lecture hall at the University of Montana. Others like me know Montana history from a Toole protege, the inimitable Harry Fritz. The thesis, Montana suffered from, and in many ways still manifests today, is the product of outside interests exploiting natural and human resources for the benefit of corporations. There was a time in Montana when corporations spoke not only as citizens, but as super citizens, and in doing so manipulated the press, elections, and legislation. The Corrupt Practices Act of 1912 was passed by referendum by folks weary of a system that bowed to money over public interest. And it's that act that Attorney General Steve Bullock has hitched our wagon to in Montana's fight to preserve our state's political integrity in the wake of the United States Supreme Court decision in Citizens United. I think it's fitting that this conversation happened in this place in Missoula. The story of this case of political speech and corruption and money is happening in our city, the one where voters overwhelmingly supported a referendum urging Congress to propose a constitutional amendment that says simply that corporations are not human beings and therefore don't have the rights of citizens. It's a privilege to welcome all of you today and this distinguished panel. Before I do the introductions, there are a couple of quick pieces of housekeeping for the panel and folks in the audience. We are recording this for community access television, which makes the microphone necessary. So if you please use your microphone when you speak, we'd all be grateful. And then folks in the audience, if you please write down any questions you may have on note cards that folks can provide for you. John and John have them in the back of the room, and they'll be happy to distribute those. And our moderator will select from those questions and ask them on your behalf. Our moderator today is Anthony Johnstone, all the way from the University of Montana School of Law. And he's an assistant professor who teaches and writes on constitutional law and related subjects. Before joining the School of Law, he served as solicitor for the state of Montana, which is much different from what I understood. I had to Google it to make it clear. In that position, he represented the state in constitutional cases in trial and appellate courts, including the Montana Supreme Court and the Supreme Court of the United States. He also clerked for the Honorable Sidney Thomas, United States Court of Appeals for the Ninth Circuit, and practiced litigation as an associate at Cravath, Swain, and Moore in New York, New York. He's an elected member of the American Law Institute and holds a BA from Yale and a JD with honors from the University of Chicago Law School. My friend Steve Bullock, ladies and gentlemen, is Montana's 20th Attorney General and is the state's chief lawyer and law enforcement officer. Since taking office, he's been instrumental in the improvement of child protection, making our highways safer by strengthening DUI enforcement, and preserving public access to Montana's streams and public lands. In the past year, he's created the Children's Justice Center, a collaborative initiative to better treat child abuse victims and more aggressively prosecute offenders. He spearheaded the 24/7 sobriety program, which has shown a 99.7% success rate in keeping repeat DUI offenders from drinking and getting behind the wheel. Most germane to today's conversation, Steve's also been the only state attorney general in the nation to defend his state's ban on direct corporate contributions to political candidates in the wake of the 2010 U.S. Supreme Court decision and Citizens United. Before that ruling, 24 states had bans similar to Montana's 1912 voter-approved Corrupt Practices Act. Now Montana, led by Attorney General Bullock, is leading the charge to defend those laws before the U.S. Supreme Court. Bullock was born in Missoula, to his credit, and graduated from the Helena Public School System and received his undergraduate degree from Claremont McKenna College and his law degree with honors from the Columbia University Law School in New York. He and his wife Lisa have 3 children, and we're happy to have Steve back here to talk about this subject of incredible importance, not only to the nation, but in particular to Missoulians today. Professor Larry Howell is the University of Montana School of Law's legal writing director. He in no way touched Jim Nugent, I note, because my memos would have been shorter. Professor Howell teaches appellate advocacy, legal analysis, and legal writing, and coaches the law school's national moot court team. He joined the faculty in 1996 after practicing civil litigation with the Missoula law firm for 4 years. And before graduating with high honors from the University of Montana School of Law, he enjoyed a distinguished career as a newspaper reporter and editor, receiving several awards for his investigative reporting. He was tireless then, and I suspect the same is true today. He's also a member of the amicus committee of the Montana Trial Lawyers Association. His outside interests include poker, legal poker, cooking, and golf, as well as hiking, fishing, and camping with his wife Ellen Leahy and his children Emily and Sam. And finally, Jerry Lindorf retired from 40 years in the practice of law in 2004 and spent most of his career practicing as a partner in the firm of Harrison, Lindorf, Postina, and Duncan. Lindorf was a delegate to the 1972 Constitutional Convention and represented the state of Montana in the federal court case challenging the election results ratifying the 1972 Constitution. Jerry has remained active in numerous professional and volunteer organizations since his retirement, and it's a pleasure to have him and the rest of the panel here today.
Thank you, Mayor Angren. I want to just offer kind of a brief overview framing the discussion today about the First Amendment, corporate speech and campaigns, and what's at stake in the American Tradition Partnership case that Attorney General Bullock is defending before the U.S. Supreme Court. When our U.S. Constitution was framed, candidates didn't campaign. They stood for election and won or lost based on their reputation. But as America democratized over the 19th century, that came with campaigning. And that campaigning came with money. Campaigning takes speech. Well, money isn't speech. If you have a right to speech, you also have a right to spend money on speech, just as if you have a right to bear arms. The government couldn't tell you can't spend money on arms. That would be an infringement of that right. Or if you have a right to privacy to make medical decisions, the government couldn't tell you can't spend money on those medical decisions. And so it has long been recognized that there is a First Amendment right of free speech, and that right includes the right to spend money on speech. The question is, how far does that right go? How can government then regulate how candidates and outside groups can spend money on speech in political campaigns? And the basic rule for several decades now, in a case called Buckley versus Vallejo, in which the Supreme Court, the U.S. Supreme Court, considered some post-Watergate reforms to federal campaign finance regulation. The basic rule is that government can regulate money in politics to prevent corruption. And as a result, government can limit the amount you can contribute to a candidate. And so contributions are subject to limits, and that is direct contribution to candidates are not at issue in this case. Montana's contribution laws are being challenged elsewhere, but these issues, Citizens United, does not involve the limits on contributions to candidates. The Supreme Court has said so far that those are constitutional. You can say that you can only give $500 or $2,000 to a candidate because of the threat of corruption, because you are actually paying the candidate. What the Supreme Court has said, and this is what is involved in these cases, is that you cannot limit expenditures. You cannot limit expenditures by candidates. You couldn't tell a candidate that he can only spend $100 on his campaign, because that is directly tied to speech. And there's no or less of a risk of corruption when a candidate is spending their campaign funds on speech. The court has also said that you cannot limit independent expenditures, outside groups spending on speech. Again, because if they are independent expenditures, if a group decides to run ads attacking or supporting a candidate, the court has said that there's no corruption risk there. You're simply running ads expressing your views or your association's views, the NRA, the ACLU, the Sierra Club. They have a right to spend as much as they want for or against candidates. In 2003, Congress passed a law that restricted all corporate and union campaign spending near elections. And that included all corporations, including not just ExxonMobil, but the NRA, the ACLU, those are all corporations. And when the Supreme Court reviewed that law in Citizens United, it struck that down. The court said that Congress could not ban corporate and union speech close to elections related to these candidate campaigns. The court did so saying that, as it had said before, independent expenditures, when a corporation, whether it's the ACLU or ExxonMobil, spends money, that does not lead to or even create the appearance of corruption. In fact, independent expenditures don't even ingratiate. In any event, such ingratiation, where a candidate might be grateful for these ads, is not corruption. Because these independent expenditures aren't tied to corruption, then the government had no interest that trumped the First Amendment right of corporations to spend. As I said, corporations include the ACLU, they include the New York Times, they include Lee newspapers, and they also included the Anaconda Company. Montana, in its own experience, the people of Montana a century ago passed its own law, and that's the law that's at issue. And that law said that corporations, including the Anaconda Company, not newspapers, but the Anaconda Company, could not spend on elections. It looks somewhat like the law that the U.S. Supreme Court struck down in Citizens United, and that brought a challenge against our Corrupt Practices Act that we'll talk about. The question then is whether our Corrupt Practices Act, which prevents these business corporations from spending in elections, violates the freedom of speech protected by the First Amendment recognized by the Supreme Court. That's what the Supreme Court, the U.S. Supreme Court, is considering now, and we'll start with Attorney General Bullock talking about that particular challenge, and then Professor Howell and Cherry Lindorf will round out the history and law around that. But that's basically what's at stake, the First Amendment right of people to associate in corporations to spend money, and how the government can regulate that spending in political campaigns.
Great. Thanks, Professor Johnstone. And it's great timing and also a great panel, I think, to discuss this issue. Great timing in as much as that Anthony alluded to, we are in the process of briefing this in front of the U.S. Supreme Court. And a great panel in as much as to understand, I think, what we are today in Montana, what our government is, what our expectations are for participation. We also have to understand where we've been. I mean, it was 1906 when the Hamilton newspaper said that the greatest living issue that confronts us today is whether corporations shall control the people or the people shall control the corporations. And they got there after like an election in 1894 in Montana to decide where the state capital would end up, spending between 35 and 70 million in today's dollars to influence 52,000 voters. Over $1,000 a vote was spent back then. It wasn't something that we were just aware of in Montana. It's Mark Twain who had a great line that said, William Clark, one of the Copper Kings, is said to have bought legislatures and judges as other people buy food and raiment. By his example, he's so sweetened corruption that in Montana it no longer has an offensive smell. So that's where we began. And that same William Clark, when he bought a U.S. Senate seat and went back to decide whether or not he'd actually get to be in that seat, had a great quote, and he said, you know, so he's in a Senate committee talking about his election or ascension, more or less. Back then we chose our U.S. senators through our legislature. And he said that many people have become so indifferent to voting there by reason of the large sums of money that have been expended in the state heretofore, that you have to do a great deal of urging. And it takes a lot of men to do it, to go around among them and stir them up and get them out. So 100+ years ago, he said there was so much money there that people don't even participate. They don't even vote. Back then, they actually had men that would go around to try to get them to come out and vote. And it's under that backdrop which that Corrupt Practices Act was passed by initiative in 1912 that Anthony referred to. And I think why it makes it a great panel in some respects is that also that in the early 70s, right, Montana got a brand new constitution. And it's a constitution where a lot of it is hinged upon active participation, and that the people having a role in the deliberations and the right to know, some sunshine laws, and what government would be. In Montana, because of that history, in many respects, I think that we have you know, some of the highest rates of participation in our political system. We also have a system where people expect to know their U.S. senators by the name of John and Max, or the congressman by Dennis. We have a system where the average U.S. senator wins spending $8.5 million. The average state senator wins by spending $17,000. And if you're a Democrat or a Republican candidate running for state house, the question asked again and again is, how many doors have you knocked? How many people have you actually spoken to? So that's the backdrop of what happened. And when the Citizens United was first taken up, that Montana actually wrote the brief that a good handful of 26 other states signed on to, saying that the vast majority of elections occur at the state and local level, not at the federal level. So that we should actually be able to be the masters, more or less, of our own destiny. They didn't necessarily accept that, and the Citizens United decision came down, as Anthony referenced, with a number of premises, saying, right, independent expenditures can't corrupt, and that there is more or less an unfettered right for corporate spending in elections. And the state of Montana then was sued by 3, and what have I used, 5 of my 10? I'll try to go quick.
Yeah,
and we can do more questions than anything. But the state of Montana was sued by three corporations. One of which was the sole proprietor out of Bozeman that said he wanted to participate and actually wanted a tax break for participation. Another one was Montana Shooting Sports Association, an advocacy group that's been active in elections, and actually has a segregated fund, our political action committee. Been active for literally decades now. And the third was a group called American Traditions Partnership. After Citizens United came down, they sued to get rid of our Corrupt Practices Act of 1912, that I think has served our state well for a century. And in putting together a record, I mean, what we did and what we offered was, we offered individuals, both Democrats and Republicans. Mike Cooney, who was a young legislator, served as Secretary of State, the Chief Elections Officer, and ran for governor as a Democrat. Bob Brown, who served as a young legislator, served as Secretary of State, ran for governor as a Republican. We offered testimony from Professor Fritz that the mayor referenced, talking a little bit about our history. We offered other things about what the political system in Montana really is. And in doing so, both Cooney and Brown said, we are different. And independent expenditures, even the threat of independent expenditures, could corrupt. and think of all the decisions, not just at the legislative, because that's what largely Citizens United was about, Congress, but think about all of the decisions, be it at a county commission level or an executive branch level, where these decisions aren't made always in the fullest of, everybody gets to listen to the debate going back and forth. But there's be some real challenges there. In doing so, in arguing that we had said that sure, we have this U.S. Supreme Court decision, Citizens United, but it's different because there's different burdens in speaking in the state system versus the federal system. I mean, the Citizens United decision talked about how, 33 different kinds of speech is regulated and reference criminal felony penalties 10 times, that you need a campaign finance lawyer just to figure out how to get through the federal election bureaucracy. In Montana, we presented testimony that says, to form a political action committee, a segregated fund, it's a 2-page form. You can even be a corporation and do it. And if it seems too complex, our Commissioner of Political Practices will help you fill it out. We presented testimony that you can even make expenditures and file within 5 days later. We presented information that said corporations are active in Montana, and they truly are, through a segregated fund or a political action committee where the dollars come from people interested in the corporation, but not necessarily the shareholders. And that it's completely transparent. We know who the genie is behind the curtain because they're the ones that are actually then filing for the reports. And so we said also the different parties, the different burdens, and the different history. And the history is something that we'll get to talk about some today as well. But not just the history, but even as of today. Montana Supreme Court late last year upheld that, upheld the Corrupt Practices Act, and wrote, the question then is, when in the last 99 years did Montana lose the power or interest sufficient to support the statute, if it ever did? If the statutes work to preserve a degree of political and social autonomy, is the state required to throw away its protections because the shadowy backers of WTP seek to promote their interests? Does the state have to repeal or invalidate its murder prohibition if the homicide rate declines? We think not. And went on with some of the same analogies of, what was the atmosphere in the 1900s, and that atmosphere could well exist today. Shortly after the new year, and recognize that we had argued all throughout that you could still uphold Citizens United, but we're different. And state elections are different. And we've actually presented a different case than was before Citizens United. The plaintiffs went to the U.S. Supreme Court, sought to stay enforcement so that the law couldn't be enforced during the pendency while it was being reviewed by the U.S. Supreme Court. And they stayed our law, so they stopped our law. So for the first time in 100 years, this Corrupt Practices Act that bans corporate expenditures through their treasuries as opposed to through a segregated fund of dollars voluntarily given isn't enforced. But what was interesting in that, in staying the law, is 2 of the justices, Ginsburg and Breyer, the whole stay was 1 page, but they took about half of it. And they said Montana's experience, and experience elsewhere since this court's decision in Citizens United versus FEC, make it exceedingly difficult to maintain that independent expenditures by corporations do not give rise to corruption or the appearance of corruption. A petition for certiorari will give the court, the U.S. Supreme Court, an opportunity to consider whether, in light of the huge sums currently deployed to buy candidates' allegiance, Citizens United should continue to hold sway. So now, and that's where, and we can go through some of the discussion, I think, in the greater thing, but that's what's in front of the U.S. Supreme Court right now. For the first time in a century, this law won't be enforced in Montana. And the court, U.S. Supreme Court, will be deciding what to do with Montana's law, or whether also to reconsider the Citizens United decision as 2 of the justices suggested might happen. All of this will be unfolding over the next 4 or 5 months. Should I stop there for now?
Yeah. Professor Howell.
Steve, you're on the cord of my microphone there. Thank you. Good afternoon, I guess it is. I want to return to the quote that General Bullock opened with. He actually stole it from my notes. I saw him looking over it. Great minds think alike. The exact quote was, "The greatest living issue that confronts the nation today is whether corporations shall control the people or the people shall control the corporations." And as he said, that was from the Hamilton Western News in 1906. It sounds like it could have been from Barack Obama's 2010 State of the Union address, where he called out the Supreme Court for its Citizens United decision with much of the same sentiment. Ironically, it was actually written by a guy named Romney, not Mitt Romney, but Miles Romney, who was the editor of the Hamilton paper. I'm sure there's no relationship there. So what it really shows, that quote shows, is how much we've come full circle. And so I guess my task on this panel is sort of to describe the origins of that circle in a little bit of detail to try to give you a flavor, if you're unfamiliar with Montana history during this period, of just how bad it was. Now the whole War of the Copper Kings began with this feud between Marcus Daly, who went on to create the Anaconda Copper Company that later became the Amalgamated Copper Company, and William Andrews Clark, who was also an industrialist, a mining baron, if you will. Now, nobody's really sure about the origins of their feud, but it became bitter after the election of 1888, the last election before Montana was a state, in which Clark was running to be Montana's territorial delegate to Congress. He was pretty much assured in his mind of winning that position, but lo and behold, when the legislature voted, he had lost substantially. And he figured out it was because Marcus Daly had worked behind the scenes and got all the
Richard, please call 3855.
all the counties that he controlled through his workforce to vote Republican, even though they were strongly Democratic. So in Clark's mind, that sort of lit the fuse. The same thing happened again in 1893 after Montana became a state, when Clark, whose single greatest ambition was that he wanted to be a United States Senator, campaigned to get the legislature. As General Bullock noted, the legislatures elected senators directly until, I believe it was 1913. And once again, he thought he had a good chance of winning. It was pretty well accepted that both he and Daly were buying as many legislators' votes as they could get, and in the end, no candidate had a majority. So this feud actually cost Montana one of its Senate seats. Montana only sent one senator back there. That sort of shows how they were putting their private interests above the state interest. Clark got his revenge, though, in 1894 when, per the Constitution that had just been adopted, Montana held an election to choose where the capital was going to be. Clark was backing Helena. Daly was backing his company town of Anaconda. They spent millions of dollars in today's dollars, and Helena narrowly won out. So Clark got a little bit of revenge. So that was sort of the general background level of what the public knew about corruption, besides what was going on at the sheriff's office or JP's, anything like that. But then there were three big episodes of corruption that got Montana a lot of attention. And the first was William Clark's attempt to be elected senator, U.S. Senator in 1899, again by the legislature. There's a pretty well accepted secret in Helena that he was buying votes of representatives and senators at the rate of $5,000 for a representative, $10,000 for a senator, and more if you put up a fight. Well, he was doing this through his son and some lawyers, and they made the mistake of approaching a newly elected senator from Flathead County named Fred Whiteside. Now, Whiteside turns out is one of the truly great heroes in Montana, and in fact, there's a plaque in the Capitol devoted to his efforts that they put up during the Watergate scandal, sort of belated recognition. But he played along and took $30,000 in $1,000 bills from Clark's men in purportedly to buy his vote and the vote of a couple of other legislators. The next day on the floor of the Senate, though, he stood up and he blew the whistle. And he called out what he called the withering curse of corruption that it was afflicting Montana. Well, that created a national scandal eventually. Didn't stop Clark from being elected, he just had to pay more money to more people. He ended up getting elected, and to show no good deed goes unpunished, Whiteside lost his Senate seat after the Committee on Credentials Committee, which was controlled by Clark's men, decided that some of the ballots that they'd counted towards Whiteside actually went to his opponent. They kicked him out of the Senate. But Whiteside and Marcus Daly and others went to the United States Senate Committee on Privileges and Election and asked them to investigate Clark's election. So during the first 6 months or 5 months of 1900, the United States Senate conducted an investigation in which they subpoenaed dozens of legislators as well as the justices of the Montana Supreme Court to travel from Helena to Washington, D.C. in the middle of winter to explain their sudden wealth. This ended up leading them to conclude that Clark had bought his Senate seat, which indeed was the case, and they recommended his expulsion. Montana got an incredible black eye out of that, and that was the first episode that really drew national attention to Montana's corruption problem. The second big episode and the third big episode actually arose out of a more, what seems like a small-scale corruption, and that was in the Butte District Courts. The first involved a trial over who owned the Minnie Healy mine, a very small mine. It was, however, located between two very profitable Anaconda Company mines. The third Copper King, Fritz Heinze, had sort of allegedly swindled ownership of the Minnie Healy out of a friend of Marcus Daly. And his plan was to use this small mine strategically located to drill underground and steal ore from the Anaconda Company. So they sued, or they got the former owner to sue and claim that Fritz Heinze did not properly own it. The case was assigned to one of two judges in Butte that were widely understood to be controlled by Heinze. The first judge was named Edward Harney. He tried the case without a jury. It was a case in equity, and ended up ruling in Heinze's favor, that Heinze owned the mine. Well, the Anaconda Company appeals to the Montana Supreme Court. And in the course of that appeal, they came up with some letters that had been written to Judge Harney from a woman named Ida Brackett, who happened to work for Heinze, about an affair that she was having with the married judge, and in which she promised him that he would be well treated, basically, if he remembered who his friends were. Now, the Montana Supreme Court was appalled by this, so they ordered a new trial in front of a different judge. Unfortunately for Amalgamated Copper at this stage, the second judge was William Clancy, who was even more beholden to Heinze. So this is the third episode. The Minnie Healy episode got national attention because of the scandal involving what were called the Deary letters between this woman and the judge. So the case gets reassigned to Clancy. This is now, by 1903, Clancy has sat on the case for a couple of years, and then he issues a ruling once again in favor of Heinze. The Anaconda Company, or the Amalgamated Copper Company, which succeeded the Anaconda Company, had had enough by this stage. They said, that's it. They shut down all their mines and threw 15,000 Montana workers out in the streets in the fall of 1903. And then they sent an ultimatum to the governor that said if he didn't call a special session to pass what was called the Fair Trials Bill that Amalgamated had written, which would allow it to disqualify judges for any reason, that it would stay shut down. And Montana's miners would largely starve in the winter if they didn't freeze to death first. So the governor held out. Hope you're not in this position someday. The governor held out for 3 weeks before finally caving in and calling a special session. They passed the legislation written by Amalgamated Copper allowing Clancy to be disqualified, and they put their miners back to work. This was the final straw, at least in the public's mind. There were national editorials about how Montana fell on its knees prostituting itself for a big company. It was naked corporate blackmail, and Montana caved in. It took 3 years after that for Montanans to do what the mayor talked about, and that's amend their constitution, to allow direct enactment of legislation by citizens, bypassing the corrupt legislators. So they gave themselves the right, by amending the Constitution, to pass citizen initiatives. That was 1906. Took 6 more years to get the Corrupt Practices Act passed. But when it did pass, it passed with 77% of the vote. That was the Corrupt Practices Act that the current version is being challenged by American Tradition Partnership. So that's where we came. It was really a reaction by the citizenry itself to an incredible level of corruption. Montana was basically a banana republic without the foliage.
For a nice segue, Senator Clark also, his first office was as, I believe, president of the original Montana Constitutional Convention. And so now we'll move to a delegate of our new and improved Montana Constitutional Convention.
Francis, if you're in the library, please come to the accounts desk.
Thank you, Anthony. I didn't appreciate the association with Clark. You know, a difference between myself and the 3 gentlemen that were also introduced by the mayor is that they all graduated with honors. I did not. And for this reason, and the fact that I'm not familiar with the topic as well as they are either, I'm going to have to rely a bit more on my notes as I speak to you. I don't like to do that. I normally do not speak from notes, or at least not the extensive notes I have today, but I hope you'll bear with me and allow me to do that. I was asked to comment on what the delegates to the Montana Constitutional Convention of 1972 did or said about corporate speech. The short answer is nothing specifically, and I'll comment a little more on what they did later. But I believe I can best contribute to this discussion if I focus my remarks principally on the free speech provision of the First Amendment. You all know that when our original Constitution was adopted, there was a vigorous debate over the fact that it lacked a Bill of Rights. And the drafters of the Constitution took the position that we didn't need a Bill of Rights. The states all had Bill of Rights, and it was principally an area that should be controlled by the state. And also they argued, because we're only granting limited powers to the federal government, we do not need to protect against abuse of powers they do not have. Well, as we know, the Anti-Federalist ultimately prevailed, and the first 10 amendments, which are known as the Bill of Rights, were added to our Constitution. These rights were aimed principally at the federal government. Well, they were aimed specifically at the federal government, not just principally. And the best example of that might be the First Amendment. It reads, "Congress shall make no law abridging freedom of speech or press," just dealing with the issue we're dealing with today. But note, it begins, "Congress shall make no law." And that was because it was clearly intended to apply to the federal government, and that's the way it was applied until after the Civil War. After that war, some additional amendments were made to the Constitution, including the 14th Amendment. And the first section of that amendment reads in part, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." Now note that the 14th Amendment, unlike the first, is focused on the states, and it's designed to protect citizens from abridgment or deprivation of the various privileges and immunities and liberties by the state. So the 14th Amendment actually begs the question, what are these privileges, immunities, and liberties? It doesn't specify them. And our Supreme Court has found them by looking at other provisions in the Constitution, and which included the Bill of Rights. And in a Supreme Court case in 1925, the Supreme Court recognized freedom of speech was protected by the First Amendment from abridgment by Congress, but it's also one of the personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. What the Supreme Court in effect did was incorporate this First Amendment right of free speech into the 14th Amendment and thereby make it enforceable against the states. Now, just back briefly to the Montana Constitutional Convention. When it met in 1972, the right of free speech was not only protected by its own Constitution, but by the First Amendment to the federal Constitution. And to the best of my knowledge, and I've looked at the report of the Committee of the Bill of Rights from that convention and the transcript from the convention, and corporate speech was just not discussed. My recollection is that the question of whether corporate speech was protected by either federal or the state constitution was not even an issue at that time. And as best I can discern, when after the citizens enacted the initiative that both the Attorney General and Professor Howell have referred to in 1912, I believe it was, I don't believe our legislature really got back to that subject until the late 70s when it enacted our current Corrupt Practices Act. It's amended that act many times, but I think that's when it enacted the bulk of it. Now, this issue of whether corporations may make independent expenditures, that's the one that's under fire now, and that's ultimately going to be decided by our Supreme Court. And as we know, Article 6 of the U.S. Constitution provides that the U.S. Constitution and the laws of the United States are the supreme law of the land. And therefore, even if Montana had put something in its constitution back in 1972 to limit these independent expenditures by corporations, it would not have helped. A state constitution can grant greater rights than the federal constitution grants, but it cannot reduce or cause to be diminished any of the rights contained in the federal constitution. Now, let's go back to the First Amendment. The U.S. Supreme Court has considered the free speech right in the First Amendment essential to our form of government. Yeah. And to consider or to evaluate how broad they consider that right, let me just refer to some of the statements made by the justices of that court. And I've singled out Justice William Brennan because he was one of the great justices of our time. At least I was living when he was still working. Not everybody else was here, I recognize. But it was back in 1964, he wrote, and he said, "The general proposition that freedom of expression on public questions is secured by the First Amendment is and has been long settled by the decisions of our court." He went on to state that it is a prized American privilege to speak one's mind on all public institutions, even if not always with perfect good taste. Brennan quoted from Justice Brandeis as follows: "Those who won our independence believed that public discussion is a political duty and that this should be a fundamental principle of American government." Brennan further stated, and that thus we consider against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and it may well include caustic and sometimes unpleasantly sharp attacks on government officials. This was a libel case he was deciding at the time, and he went on to say, "The constitutional protection does not turn upon the truth." popularity, or social utility of the ideas and beliefs that are offered. And he added, erroneous statements are inevitable in free debate and must be protected if the freedom of expressions are to have breathing room and space they need to survive. So our free speech right is not only essential to our form of government, but it protects speech that is uninhibited, not in good taste, caustic, not necessarily true or popular. These decisions interpreting the First Amendment make it clear that Americans are free to speak their minds. And it wasn't talking about corporations at that time. Currently, and this is in the decision, the Citizens United decision that is being discussed here, Justice Kennedy, in dealing with speech by corporations, stated the First Amendment prohibits restrictions that distinguish among different speakers, allowing speech by some but not by other. Political speech, he said, is indispensable in decision-making in a democracy. This is no less true because the speech comes from a corporation. Political speech in decision-making in a democracy, excuse me, I read that wrong. Political speech is indispensable in the decision-making of a democracy. And this is no less true because the speech comes from a corporation rather than an individual. These statements of the Supreme Court tell us that it's reluctant to limit speech, very reluctant to limit speech. It prefers more speech to less speech, and it appears it will err on the side of protecting speech in dealing with any limits that might be imposed upon it. That being said, it's also long established that freedom of speech does not confer an absolute right to speak or publish. It is my view, despite the citizens of United, that a state may still impose some limits on speech that are reasonable under the circumstances. It is also my view that even with regard to political speech, the state may and should require identification of the speaker and how much the speaker was paying to get his message out. By identification of the speaker, I do not mean the voice on the radio or the people necessarily appearing in the TV commercial. I mean the money should be traced back to the person whose interest is being protected. We all have reputations, interests, and a history. And when our identity is disclosed, our statements may be better judged. I believe this to be consistent with the First Amendment because the First Amendment is not only to allow a speaker to speak, but allow people to receive information. And these disclosures make information more complete. Now, let me conclude by saying that although many of us are concerned about the decision in Citizens United, this country has survived a lot of public officials, a lot of Supreme Court decisions, and even if this decision cannot be modified, we'll survive it. But if you're one that disagrees with that decision and it's causing you some depression, it might help you to keep in mind that decisions by the Supreme Court are not final because they're right. They're right because they're final. Thank you.
Thank you, Jerry. So I wanted to give a chance now for the panelists to respond to each other, and as you're talking with each other, we can take cards from the audience in terms of questions. So right now there are some people walking through who can pick up cards to bring them up here. But in the meantime, responses?
Yeah, I guess mostly picking up on what Jerry said, and it largely right on the First Amendment. But there's a couple of the premises behind Citizens United that I don't think has necessarily been borne out. One of which is that, you know, we all recognize that there can be restrictions placed on our speech. You can't, you know, the classic example is you can't go into the middle of a movie theater and scream fire. That where the state can demonstrate compelling interests, we can have those restrictions. And interestingly enough, I think one of the underlying premises too behind the Citizens United decision was that, and Jerry mentioned it, that you really, the First Amendment doesn't distinguish among speakers. Well, even since that decision's come down, a number of foreign nationals sued and said, I want to actually participate in the political system. Well, the court said, no, you can't. So we do distinguish among speakers. And when you're really talking about a corporation is a creation of state law. We in the state of Montana, we write the laws that say, here's how a corporation can exist. If you're a foreign company, and even Citizens United said, well, we're not going to address what happens with these foreign corporations, you know, these overseas corporations. But if you're a foreign company that wants to transact business in Montana, you have to register with our Secretary of State's office, and we can put some restrictions on it. The absolutism of the First Amendment, where there's been restrictions in the past was, and especially in political speech, was also the notion that the potential for corruption, right? If a person gives candidate A hundreds of thousands of dollars, could that corrupt? And what becomes down in with the Citizens United decision in part, and Professor Johnstone mentioned that, is, do we live in a world where an independent expenditure or a threat of an independent expenditure couldn't corrupt? Is it just the straight direct for dollars? And was the U.S. Supreme Court deciding that as a matter of law, saying that no matter what record you gave them, you could never demonstrate that an independent expenditure could corrupt? Finally, then I'll be quiet. And Jerry mentioned that was also one of the premises that I think of Citizens United, but we'll have disclosure, right? So at the end of the day, as long as we know who the speakers are, this is going to be okay. One of the groups suing us had in it sort of promotional materials that tried to raise money. It said, finally, we're not required to report the name of any amounts of contributions that we receive. So if you decide to support this program, no politician, no bureaucrat, no radical environmentalist will ever know that you helped make this program possible. The only thing we plan on reporting is our success to contributors like you who can see the benefits of a program like this. You can just sit back on election night and see what a difference you've made. And be it already in our state races, there's been some mailers against Republican candidates where we don't know who the genie behind the curtain is. Who are the interests speaking? After Citizens United came down in the 2010 election, 501c4 groups, so nonprofits that didn't disclose who they're spent more than $120 million in the midterm election. There are things about our law that cure some of the disclosure issues. But if we're really premised on that independent expenditures could never corrupt and disclosure will take care of it all, that's where I think that, again, Justices Ginsburg and Breyer said, it all sounds good in a textbook, but that's not what we're seeing actually at the results. And we've actually seen a lot of differences from 2010 to today when the Citizens United decision came down.
Other comments, follow-ups?
Doing it again.
I steal your speech, I steal your microphone.
A couple of things about Citizens United that I want to get back to, because I recognize, I appreciated the way Jerry said that you know, that Supreme Court cases aren't the law because they're right because they're the law. But Citizens United is a terribly flawed decision, both procedurally and substantively. not the result. If they could get to that result some other way and defend it, that'd be fine. But I don't know how many of you know the procedural history of Citizens United. It concerned a movie called Hillary, the documentary. That was a hatchet job on Senator Hillary Clinton when she was running for president. It was 90 minutes long. Now, I don't know anybody, except maybe the producers of that, who are voluntarily going to sit down and watch 90 minutes on Hillary Clinton. Recognizing that, they cut a deal where it would be offered on pay-per-view cable. So people who wanted to watch that had to go out and affirmatively sign up. So it's not a political commercial in the traditional sense. And when it went up to the U.S. Supreme Court on appeal from Citizens United, it was a facial, it was an as-applied challenge, meaning the Citizens United people said, well, regardless of what the law says, that doesn't cover us because this is a pay-per-view documentary. So the case is argued in front of the U.S. Supreme Court on that basis. After the argument, the Supreme Court issues its own order saying, you know, we want you to re-argue this without anybody asking them to, and in doing so, we want you to consider whether we should overturn 2 of our own cases and strike down a federal statute. And so that's the procedural posture that they heard of. And, you know, that's judicial activism. Now, maybe it's justified, maybe it's not, but it's flat out judicial activism. Nobody asked them to do that, not even Citizens United. And they didn't have a record in which to do that. So they reached back to a case from 6, 7 years earlier in which they had a record, but completely different facts. And they said, well, based on that record, we can say that this law is unconstitutional. The problem was, in that case, on that record, they said it was constitutional. Okay, so this was really goal-oriented justice. I'm editorializing here, but it's a panel in a library. I figure I can do that. That's the first problem with Citizens United. The second is just the reasoning. Professor Johnstone alluded to some of this, but in his neutral, even-handled manner. But think of this statement. We hold that political independent expenditures are incapable of causing corruption. Anybody believe that? Anybody believe the casino owner in Las Vegas who gave Newt Gingrich $10 million in independent expenditures doesn't expect something in return? And that Newt Gingrich, had he been elected president, wouldn't have been favorable to the casino interests? I mean, maybe he wouldn't have, but it certainly creates the appearance of corruption, which has been treated as bad as corruption itself. So when they have statements like that in there that just don't pass the laugh test, you have to go, what were they thinking? And then here's the final one that they justify it sort of underlying the whole decision as, well, we're a representational democracy. Our legislators and executive branch officials are supposed to reflect the wishes of their supporters. So what's wrong with that? The fact that a campaign expenditure gives a little access to a politician, that's the way the system's supposed to work. The problem with that is they don't elect judges at the federal level, and we do at the state level. And I don't think anybody in this room or in the U.S. Supreme Court thinks it's a good idea for state judges to grant access, special access and privilege to their campaign contributors. That's just wrong. So one of my goals of all this litigation is that even if they don't walk back Citizens United, they should at least start carving out some exceptions, and one of them would be for judicial elections, that they could have greater restrictions on judicial elections because the need for complete independence of the judiciary is much greater than the representative branches of government.
Jerry, any follow-up?
No, I generally agree.
You have to take the microphone. You're on TV.
I generally agree with what you said, Larry, regarding the election of the judiciary. But I think with regard to legislators who are representatives, we have to expect, for example, a farmer coming from an agricultural area, he'll receive a lot of contributions from other farmers, oppose an increase in tax on agricultural land, whether he was a farmer or not. And in that area, You know, there's so many things like that that can appear to be corruptive, and they're not. But with the judiciary, I mean, I fully agree. I can remember as a young lawyer, an older lawyer telling me, I contribute $400 to every judge that runs for the Supreme Court. He says, but they still decide against me in all my defense cases, although they decide all my plaintiff's cases for me. And it said something good about the Supreme Court, I guess, but not about him. But the point is, it's, you know, people seek to influence other people. And that's why I think disclosure requirements are so important, you know. And I quit giving to judicial candidates some time ago for that reason. But you know, if there's a good candidate, shouldn't you support him to get out there too? It's a conflict you have with yourself. And I don't criticize any lawyer that contributes to a judicial candidate. It's important to have good judges, and I think we probably know them better than anyone else. But you know, it's a tough question to find a real good solution to. People are humans, and we're subject to some corruption, unfortunately.
Well, we have some great questions from the audience. I've kind of grouped them together, but the first one, several people have asked questions along these lines, focuses on what is the specific nature of the corporation that makes corruption a greater threat as opposed to just wealth per se. So all of Professor Howell's examples, none of those were independent expenditures. They were bribery, they were awful labor practices, but they weren't independent expenditures. And yet, Hines and Clark could form a Copper King super PAC even under Montana's current Corrupt Practices Act by spending their own money that they earned from the corporation. And so given both of those things, that the corruption in the past hasn't been independent expenditures, and that wealthy individuals like Clark and Hines could still form a PAC to spend as much money as they want, what is it about the corporation in particular that is especially corrupting in ways that wealth per se is not?
The real root of the problem with Citizens United is, as Professor Johnstone mentioned in his introduction, a case in the 70s called Buckley v. Vallejo, in which the U.S. Supreme Court said just that individuals cannot be limited in any amount that they want to spend independently of a candidate's campaign. Okay? Because, and they didn't go as far as Citizens United did, but because they said, we're not convinced that can cause corruption because it's an independent expenditure. Now, I have the same problems with that I have with corporations doing it, but I think that's a very legitimate point, that preventing corporations from doing it doesn't stop the problem. But it does allow an anonymity level that I think exacerbates the problem, that it's easier for a corporation, the people behind a corporation, not to put their names out on a limb. We didn't see very many people doing what Sheldon Adelson did, the Las Vegas casino owner, or the Cook brothers do, and that's give money directly in their name until it became sort of more acceptable for everybody to do it. But that's a fair question. So the better answer, I think, goes back a long time in Supreme Court precedent, that corporations shouldn't be treated the same because they don't have a conscience. People can support a judge candidate because they think he or she is the best judicial candidate, regardless of whether they agree with that person's political philosophy. But corporations are created to further their interests that they're created to further. They can't, by definition, act altruistically. That's shortchanging their shareholders, or that's not furthering their political goal if they're a nonprofit. They're not human. So that's one of the answers. So it may not fix the problem, but I think you can draw distinctions based on the fact that they are non-sentient beings.
I guess I'd only add to that, and that was one of the sort of interesting parts of Citizens United, because it said to the extent that there's problems that could be taken care of through procedures of shareholder democracy. Well, at the end of the day, 70% of the publicly traded corporations in America are owned by institutional investors, retirement funds, pensions. So how many of you either have you're paying into a retirement fund or a 401k? All of those, there is no notion of shareholder democracy that could take care of that. And you don't even know who you're investing in necessarily. And I think as Professor Howell said, that as a corporation, if I'm an officer or director of a corporation, I have a fiduciary duty to maximize the value to that corporation. So theoretically, every corporation has a fiduciary duty. If Representative Jones isn't good for that corporation, has a fiduciary duty to make sure that Representative Jones goes away. And I don't think that that's what's envisioned by our First Amendment or our participatory process. And I think that when you're spending your own money, as difficult as Buckley v. Vallejo and the idea that this casino magnate is spending his own money, we can be upset about that or offended that he can speak so much louder than we can. But when you're spending somebody else's money, and that's what Citizens United allows, is money directly from the corporate treasuries. I mean, we've had great corporate participation in Montana, and it's through a segregated fund. We have from the Tri-County Beverage Association represented small groups to Blue Cross. They participate through PACs. We've had that participation. We could continue to have that participation.
Yeah, I think about the only thing I can add is the corporation itself, because it often can accumulate a lot more in the way of wealth than an individual, has an opportunity, particularly if in private, and would be more tempted to engage in some quid pro quo arrangement. Whereas an individual who's no different really than the people running the corporation often doesn't have those same opportunities. And you know, I'd continue to assert that disclosure, although certainly not a cure-all, is always helpful in those situations.
So another group of questions picks up on the point that states elect different officials than the federal government. Of course, in the federal government, we're only talking about Congress and the president. Not only judges distinguish state elections, but there have been several questions about a land board that can make major decisions such as leasing coal leases, hundreds of millions of dollars of resources, all of which are run by elected officials. Obviously, there are prosecutors and others. There's the Attorney General who has to decide which cases to bring and defend in court. So could you talk a little bit about, maybe it's best to start with Attorney General Bullock, about why these other state political offices, other than judges, also present some differences with Citizens United?
Yeah, and that's actually in our reply brief, one of the things that, or in our brief in opposition, one of the things that we point out is that, think about even what our Montana Constitution affords. Constitution provides for direct election of legislators, election of statewide officers, judiciary, election of local government. Each of these provides that opportunity. And Mike Cooney, as a former Secretary of State and as a former member of the Land Board, had used actually the Land Board as one of the examples, is that many decisions are made. It doesn't have, I guess, the same, it's not like a legislative deliberation, but it's the executive branch that are making decisions where independent expenditures could be much more likely to corrupt. Take it down to the local level. a zoning decision, a county commissioner on a zoning decision, that could end up, just even the mere threat, which is something that we presented, could corrupt. When you're dealing with the huge companies, be it a coal company or otherwise, and what's nice in Montana right now, although that's being challenged as well, is that a legislator can take $160. That's the maximum contribution. So it's unlikely that a Copper King's going to get a lot out of that person for the $160 because their old high school teacher can give the same amount. With the threat of unlimited independent expenditures and also undisclosed, because until we work out all those disclosure issues, if they can ever be worked out, the mere threat and the public not knowing who the genie is behind that curtain, I think, can make a substantial difference.
Any other comments? Another set of questions asked about how to draw the line in terms of the corporations that we're talking about. And so the New York Times, in fact, the New York Times was the person, the corporate person, whose rights were being vindicated in the case that Jerry Lindorf discussed. So you have the media, you have nonprofit corporations. How are we supposed to draw the line between the corporations that should be allowed and already do endorse candidates, like the New York Times or perhaps the Sierra Club, and the corporations that shouldn't be able to participate in politics directly with their treasury funds?
I'd like to hear Professor Johnstone's take on that.
Anyone else? No? Well, I think it's a good question, and it's a harder line to draw in today's media environment where the New York Times and corporations, and of course, as the Montana Supreme Court recognized, the copper collar, to quote a title of a book about it, of newspapers owned by mining interests, which was the media, which was not prohibited from spending, would be exempt from the Corrupt Practices Act as it currently stands, was a key organ of political influence over time. And so how you draw these lines is very important. We wouldn't want to say that newspapers, maybe we wouldn't, that newspapers can't endorse candidates, but of course most newspapers are incorporated. Similarly with nonprofits. I think the way that, I'll go back to Attorney General Bullock on it, I think the difference between them is you have to go the next level and ask, well, what are they for? If people voluntarily give money to the Sierra Club, which is incorporated, because that's a good way to run an association, they're consenting to their money being spent in a way that you or me investing in a mutual fund is not consenting. And so they're not really spending other people's money because the other people have jointly associated. Similarly, in a newspaper, although the lines do get blurry when you have, say, GE owning NBC or Fox owning both media and non-media properties, there is something about the function of those corporations that it's worth paying attention to. And so you have to be careful about drawing lines, but the lines might be drawn in a way that still protects a wide open dissemination of opinion and facts through the media. That's where at least you'd start, and it's a line that actually has never caused anyone trouble until Citizens United. So.
And yeah, and in Citizens United, I mean, that was one of their statements as well. We have these media corporations, and they're a corporation, and they actually influence elections. But I mean, you don't have NBC or Fox or others that are unlimitedly spending to say Representative Jones is a bad person. So I think there will be always the gradations. We do want to protect the press and the ability to speak, but not necessarily, I think it's an argument that proves too much to just lump it all in.
I think we have to be very careful there when we try to start to draw lines between which corporations will allow to speak and which we will not. Even the business corporation can make an argument that they're very much affected by government and should be entitled to criticize it. I tend to agree with the Supreme Court when it says, we shouldn't distinguish between speakers. We can sometimes look at what's being said. The example Steve gave about shouting fire in a crowded theater, but not too much else. I just think that we're probably limited, as I read the Supreme Court decisions, to seeking disclosure, to showing who these people are. If they're professing in their TV ad to be the Archbishop and they're not, that needs to come out. But it's going to be hard to say that one corporation can be critical of candidates and public matters and another corporation may not. You may be able to say there are certain areas they can't get into, possibly. I don't know if I could even find those, but I don't know. I think free speech is just so broad now that we can't say corporation A can talk and corporation B cannot.
Professor Allen?
I almost think that we need to get more creative in how we approach this and not look at the speaker, but look at the form of the message itself. Hillary, the movie, was 90 minutes long. Nobody's going to sit through that unless they want to. Right? A book is clearly protected, even if the book trashes President Obama. That's protected. Anything written, you have to voluntarily agree to pick up and consume. But what we're really talking about are these 30-second, completely worthless TV ads that contain no information of value and very little accurate information if you parse it out. And it seems to me there ought to be some way of limiting those, and that's what the McCain-Feingold Act tried to do, although I don't think it limited it to TV ads, but it basically said within 30 days of a primary election or 60 days of a general election, you can't publish or you can't broadcast an electioneering communication. And it seems to me that's completely different. That's invading your home, even if it's on a cable channel. You're watching something, all of a sudden John Tester shows up or Denny Rehberg shows up or even worse, Karl Rove shows up, and you're subject to it. You can turn it off, but it's still not the willing choice to pick up a piece of campaign literature. And I frankly think that would be a place that we could look at drawing the line.
So, and maybe this is a good kind of last round of questions and responses. Several people have asked what we can do, what we as Montanans can do, both to support our Corrupt Practices Act, but also in the worst case scenario, if the Supreme Court strikes it down, what should Montanans do, what can Montanans do about the issues of corruption that we've been discussing today, particularly in the absence of a Corrupt Practices Act if the Supreme Court acts in the worst case scenario and strikes it down?
Do you want to go ahead?
No, I'll defer.
Okay. Well, the thing we can always do is reflect on what Jefferson said, the price of liberty is eternal vigilance, and like we're always asked to do, get more involved in public life, and it's essential we do that. If we do, it's much more difficult for someone with a lot of money and only access to a corporation or access to television, extensive television. They can get a message out repeatedly and often, but if citizens, and Montana maybe is better suited to it. We're mostly small communities, sort of get the word around, I guess. You know, let people know what they know, and there should always be an opportunity to respond, and this is off the subject a little bit, and that's one of the things I liked about the federal act that prevented I think it was certain ads within the last 30 days of a primary election and 60 days of a general election. It created, I thought, an opportunity for response, and that so people would not be misled by this type of thing.
Yeah, I think there are a few things. Knock on wood, hopefully, that the court reconsiders some of the things, its parts of the decision, Citizens United decision, or can find ways to uphold our Corrupt Practices Act. It served Montana for a century well, and I think it could for the next century. Short of that, there are a number of different efforts now to even amend the Constitution to try to make that clear. There's an initiative in Montana dealing with some of the same issues. I think there's also that we need to go into the next legislative session thinking, is there room in Citizens United for us to change our laws, both to increase disclosure, as Jerry mentions, but also, as Professor Howell mentions, that we are the masters of these corporations, or at least our state laws are. So what can we do in changing our state laws to say that we have certain expectations in the state of Montana? It's, maybe that's where Jerry began it, or came close to ending at the beginning, was saying that in a lot of ways there's some dark days, and it's some real challenges as we look at this decision. But I think that we also now have to be able to, whatever the guideposts are set, say how can we best preserve what we like about Montana and our participation, our vitality of our representative system within whatever those guideposts are.
Any follow-ups? Yeah, Jerry.
Just one thing, we don't want to waste our energy either, and did someone on this panel say, or am I recalling it from somewhere else, that there's a proposed constitutional amendment to say corporations are not human? That in itself I don't think would do anything. There was another phrase, I think, to say that they don't have the rights of citizens, perhaps, and you know, I would look at that carefully too, that the due process clause of the 14th Amendment uses the word person. And person, and I haven't done the research, I don't know what it meant back in those days, but today it includes corporations when we use that word. So a corporation might still have some protection under the due process clause. But in any event, I think it's important, you know, none of us have a lot of time, that we don't waste it on something that isn't going to help us, whatever we're pursuing.
We have a little more time, just a minute, and because there are a couple of questions here, maybe General Bullock can answer it. So who is American Tradition Partnership, and trying to look beyond this? And does the state, with or without the Corrupt Practices Act, have the resources to, you know, cops on the beat have the budget to find out who these groups are and inform the citizens about it, and go after the people who are breaking the laws that are upheld when all is said and done?
Yeah. As far as who American Traditions Partnership is, that was actually both of the judicial decisions said, we don't really know who these people are. So that's one of the challenges. You know, you could say, well, it used to be called Western Traditions Partnership. It was based out of Denver, had a Washington, D.C. phone number, on and on and on. But how some of these cases came about, and recognize that this is one of a few cases going on in Montana. Not only to strike down a Corrupt Practices Act, but to get rid of all limits on corporate contributions to candidates, to get rid of all contribution limits, to get rid of all disclosure, to get rid of essentially all regulation of our campaign practices, all brought by 3 different lawsuits brought by American Traditions Partnership. It shows not only a challenge in Montana, but in other places as well, with some of the 501c4. So it's a nonprofit status that unless their supposed primary activity is political, they don't disclose their donors. So this is a group who's been very active, and I think has already been active in some legislative races this session, and it's never registered with the Political Practice, Commissioner of Political Practices. So you don't know who it is. You don't know who's making expenditures. A Commissioner of Political Practices complaint was filed against them, and findings were made. And I think that that's still in the middle of battles and fighting as far as what information will ultimately be gleaned out of them. As far as the resources, and that's the, you know, we need to get to a point where we have the transparency. Even if you went where Jerry says, we need to know who the speakers are speaking. And it's ultimately through, it's not regulating the speech, but saying we need to have those individuals, the disclosure, you know, the upside of, one of the many upsides of Montana, and when we say, here's how easy it is to speak in our elections, is that our whole sort of campaign bureaucracy to police these are in a small house on 8th Avenue in Helena with 1 full-time employee. No, I'm sorry, somebody that's appointed, and then 4 employees in total. Not a lawyer on staff. So it's not necessarily, we as a state haven't invested the resources in the past, but I don't know that we've been faced with the challenges now of all this spending that we're starting to see more and more. So it's something that I think the next legislature may well look at.
Well, thank you all very much, and thank you, audience, for joining us. It's entirely appropriate to applaud for this panel. You've all given us plenty to think about, and I'm trying to decide whether I'm excited or depressed, or or maybe some combination thereof. But I think that's sort of the beauty of these complicated issues, and the fact that we can have these conversations, that they're thoughtful and civil, and I think informative, reflects well on our state, our place, and our people. So thank you all very much.